Chapter 20. Injunction against exercise of the power of eminent domain. Analysis. Section 1879. Section 465. General principle. It has come to be generally recognized that injunction against the unlawful or improper exercise of the power of eminent domain constitutes an independent head of equity jurisdiction, uncontrolled in its exercise by the principles which regulate injunctive relief against trespass. The constitutional guarantee that property shall not be taken for public use without just compensation by agents of the state to whom this power is delegated, is deemed to establish a right of so high and sacred a character that any threatened infringement of the right should be restrained, without consideration of the inadequacy of the legal remedy. Injunction, in this class of cases, is a matter of strict right, not of equitable discretion, although it is true that special equities, such as acquiescence or estoppel, may constitute a defense. It is eminently true, in this connection, that judges have been brought to see, and to acknowledge, contrary to the opinion of Chancellor Kent, that the common law theory of not interfering with persons until they shall have actually committed a wrong is fundamentally erroneous, and that a remedy which prevents a threatened wrong is, in its essential nature, better than a remedy which permits a wrong to be done, and then attempts to pay for it by the pecuniary damages which a jury may assess. The fundamental principle now generally accepted is well expounded in the following extract from the opinion of a most able court, and is further elucidated in the excerpts in the following note. The principle upon which a court of equity proceeds, in interfering to prevent bodies corporate having compulsory power to enter upon, take, and appropriate for their own uses the lands of others, differs materially from the principle upon which it intervenes to prevent the commission or continuance of waste, or of nuisances, or of trespasses, when only private rights, or the acts of persons, natural or artificial, not having such powers, are involved. In the latter class of cases, if the right be strictly legal, and there is no relation of privity between the parties, it is of the essence of the jurisdiction of the court that a case of irreparable injury should be shown, a case for which the courts of law do not furnish an adequate remedy. It is most essential to the preservation of the rights of private property, to the protection of the citizen, and to the preservation of the best interests of the community, that all who are invested with the right of eminent domain, with the extraordinary power of depriving persons, natural or artificial, without their consent, of their property, and its possession and enjoyment, should be kept in the strict line of the authority with which they are clothed, and compelled to implicit obedience to the mandates of the Constitution. A court of equity will intervene to keep them within the line of authority, and to compel obedience to the Constitution, because of the necessity that they should be kept within control, and in subjection to the law, rather than upon the theory that they are trespassers, or that the injury which they are inflicting is irreparable. The owner of the land has the right to say that, unless they keep within the strict limits prescribed by law, they shall not disturb him in the possession and enjoyment of his property. The power is so capable of abuse, and those who are invested with it are often so prone to its arbitrary and oppressive exercise, that a court of equity, without inquiring whether there is irreparable injury, or injury not susceptible of adequate redress by legal remedies, will intervene for the protection of the owner. While the above seems the sounder principle on which to base injunctive relief in this class of cases, many courts are content to rest it on the general doctrines concerning irreparable injury of a permanent character, going to the destruction of the inheritance. On whichever ground the jurisdiction is based, the rule is now almost universal that an entry upon private property under color of the eminent domain power will be enjoined until the right to make such entry has been perfected by a full compliance with the Constitution and the laws, whether such compliance is lacking either through failure to pay, tender, or deposit just compensation as required by law, or through invalidity of the condemnation proceedings, or of the statute under which the right to enter is claimed. It appears that the entry may be enjoined pending appeal from the condemnation proceedings, unless the statute declares that the right to enter is not suspended by appeal, in which case the constitutional guarantee is sufficiently satisfied by the award of damages by the inferior tribunal, and the payment, tender, or deposit of the same. The above cases illustrate the principle as applied to railways, streets and highways. Illustrations of its application to takings for other public uses are appended in the note. Section 1880. Section 466. No injunction against prosecution of condemnation proceedings. It is to be observed that where injunction is granted against the exercise of the power of eminent domain, the entry upon or appropriation of the plaintiff's land is the specific act enjoined. No injunction lies against the prosecution of condemnation proceedings when the matter which is set up as a ground for injunction may be urged as a defense in such proceedings. Section 1881. Section 467. Railroads in streets and highways. In approaching a consideration of the vexed subject of the abutting owner's remedy in equity against railroads of various kinds in streets, it is necessary first to lay to one side two classes of cases. 1. Those holding that a railroad of some particular sort is a legitimate and proper use of the street or highway, and does not create an additional burden or servitude. This is generally held of horse and electric railroads, while the contrary, at the present day, is generally held of steam railroads. If the particular use is held to be a proper and legitimate one, the abutting owner has no substantive right to be protected by an injunction. 2. Cases where the railroad is constructed without proper authority, and the question, therefore, is 1. Not of restraining the exercise of the eminent domain power, but of the remedy of the abutting owner, as one specially injured, to restrain a public nuisance. Granting that the railroad whose construction or operation is sought to be enjoined creates an additional servitude in the street, it is found that the abutting owner's remedial right to an injunction, or even his right to any remedy whatever, is, in many jurisdictions, made to depend upon the fact of his ownership of the fee of the land included in the street. If the fee is in the abutting owner, affected only by an easement in the public for legitimate street purposes, a permanent diversion of the street to other purposes, authorized by the proper public authority, constitutes a taking of such owner's property which will readily be enjoined if just compensation is not provided. The case is otherwise if the ownership of the street is in the municipality. This rule has been most strongly reprobated by eminent writers, as making the owner's remedial or substantive rights depend on the merest technicality, and it was thought that the departure from the rule by the courts of New York in the elevated railroad cases marked a period of transition, and pointed to the eventual overthrow of the rule. It can hardly be said that that result has yet been reached. Section 1882. Section 468. Same, fee of street in abutting owner. It is the almost universal rule, that the owner of land abutting upon a public street, who owns the fee in such street subject to the public easement, can enjoin the laying of tracks, and the use and occupation of such street by a steam railroad company under authority of a municipal ordinance, in such manner as to create an additional servitude upon the street, where no compensation to such owner has been ascertained or made. In most of the cases no distinction appears to be made between the owner's remedial right to an injunction against a taking without compensation, when his land is thus affected with a public easement, and when he has the full beneficial use of the land. In others, the question of injunction is treated as one addressed to the discretion of the court, which should balance the relative inconvenience and injury to the parties and the public likely to result from granting or withholding the writ. In a few jurisdictions the courts refuse to recognize any distinction as to the abutting owner's rights based on his ownership of the fee in the street, holding that there is no taking of his property, but only of the public easement in the street, and the same courts refuse to enforce by injunction the constitutional provision against damaging property without just compensation, unless the damaging amounts to a virtual destruction. Section 1883. Section 469. Same, fee of street in the municipality. Where the abutting owner has not retained the fee in the street, but that is vested in the municipality in trust for the public, it is probably the rule still generally held that the injury to his easements of light, air, and access caused by the authorized construction or operation of a railroad in the street constitutes no taking of property within the meaning of the constitutional inhibition, and therefore no ground for an injunction. To remedy the gross injustice and hardship of this rule, nearly all recent state constitutions have prohibited the damaging or injuring of property for public use without just compensation. This constitutional provision, however, has not, like the former, generally been construed by the courts as requiring the aid of an injunction for its enforcement. A reason for making this distinction is found in the difficulty of ascertaining, before the railroad is actually in operation, the amount of damage that will be caused to abutting premises, also in the fact, sometimes referred to, that legislatures have not seen fit to provide a procedure for condemning the easements of abutting owners or appraising the damage to their property. They are therefore left to pursue their remedies at law for the recovery of such damage as they may suffer, unless, indeed, some incident such as the insolvency of the railroad company renders the collection of the damages recovered impossible, and the intervention of a court of equity essential. In a number of states, while the abutting owner is usually left to his legal remedy, if the operation of the railroad amounts to a total obstruction of the street or of plaintiff's access to his premises, or causes a destruction of his property for the purposes for which it was used, equivalent in effect to a physical appropriation of the land, he may resort to equity for an injunction. Section 1884. Section 470. Same, New York Rule, Elevated Railroad Cases. The New York doctrine as laid down in the Elevated Railroad Cases appears to have, as yet, but a slight following in other states, but these cases are so notable from their vast number, the eminence of the counsel engaged in many of them, and the thoroughness with which the fundamental principles are discussed and subsidiary rules worked out, that a somewhat full statement of the chief conclusions arrived at seems called for even in a work of an elementary character. It is important to notice, however, that these conclusions are held not to apply to a steam railroad on the surface of the street, operated in such a manner as not to obstruct public traffic. The doctrine was thus summed up in one of the leading cases of the series. The decisions of this court have settled the rights of abutting property owners to an easement in the street occupied by the defendant's structure, for free egress and ingress, and for the free admission of light and circulation of air. That easement is property, and constitutes an interest in real estate, and because their defendant's railroad was a use of the street not originally designed, and was an appropriation to themselves of property rights, it cannot be maintained without compensation being made to the abutting owners for the injury inflicted upon their property and rights, and, for the annoyance caused through the operation of the road to the abutting owners, in their enjoyment of the use of their property. They are entitled to recover such damages as may be shown to be the result of the defendant's acts. Story v. New York etc. Eco, 90 N. Y. 122, 43 AM. 146, La v. New York etc. Railroad Co., 104 N. Y. 268, 10 N. E. 528. Although property owners have a remedy at law for the intrusion upon their rights, yet, as the trespass is continuous in its nature, they can invoke the restraining power of the court of equity in their behalf, in order to prevent a multiplicity of suits, and they can recover the damages they have sustained, as incidental to the granting of the equitable relief. Williams v. New York Cent. E. E. Go. 16 N. Y. 97, 69 AM. December 651, Henderson v. New York Central Eco, 78 N. Y. 423. The violation of the property rights of abutting owners being adjudged in such an action, the awarding of damages sustained in the past from the defendants follows, they being, on equitable principles, deemed incidental to their main relief sought in a common law, as distinguished from an equitable action. The abutter can only recover such temporary damages as have been sustained up to the time of the commencement of the action, and is not entitled to damages measured by the permanent diminution in the value of his property. But the owner may resort to equity for the purpose of enjoining the continuance of the trespass, and to thus prevent a multiplicity of actions at law to recover damages, and in such an action the court may determine the amount of damage which the owner would sustain if the trespass were permanently continued, and it may provide that upon payment of that sum, the plaintiff shall give a deed or convey the right to the defendant, and it will refuse an injunction when the defendant is willing to pay upon the receipt of a conveyance. The court does not adjudge that the defendant shall pay such sum and that the plaintiff shall so convey. It provides that if the conveyance is made and the money paid, no injunction shall issue. If defendant refuses to pay, the injunction issues. The award of damages for past injuries sustained being incidental to the equitable relief, the defendant is not entitled to a jury trial of such claim for damages. Actual damage suffered by the abutting property is of the gist of the equitable action. A court of equity is at liberty to disregard the mere technical trespass upon the abutter's rights, and to refuse an injunction, in a case where the plaintiffs are unable to show any actual damage to their property, or loss suffered, by reason of the defendant's acts, and in the face of the fact that, by reason of the presence and operation of the elevated railroad in the street, the value of their property has greatly increased, and that it has shared equally with all the property in the vicinity in the general increase of values which has taken place. Section 1885. Section 471, changing grade of street, other uses of streets, vacating streets. Here, again, it is necessary to segregate the cases which hold that the injury caused to the abutting owner by the action of a municipal or other authority, acting within the limits of its power, in raising or lowering the grade of a street confers no right of action whatever upon the abutter, and cases holding that such structures as electric light poles, telegraph or telephone poles, and the like, create no additional servitude in the street. If the abutter owns the fee in the street, and such structures are held to create an additional servitude, and are shown to abridge the right of the abutter to the use of the street as a means of ingress and egress, or otherwise, a proper case is made for an injunction until compensation is made. In the limited class of cases where the injury caused by a change of grade is held to constitute a taking of the abutter's property, it seems that an injunction may issue in accordance with the general principles governing injunction against the exercise of the eminent domain power. Where, under the modern constitutional provision, damaging property for public use without compensation is prohibited, and paying or securing the compensation is treated as a condition precedent to doing the work which causes the damage, an injunction will usually be granted until the condition is complied with. The considerations which should guide the court in granting or refusing the injunction at the suit of the abutting owner in such cases are thus stated in a most instructive opinion by Judge Brewer. First, a chancellor, in determining an application for an injunction, must regard not only the rights of the complainant which are sought to be protected, but the injuries which may result to the defendant or to others from the granting of the injunction. If the complainant's rights are of a trifling character, if the injury which he would sustain from the act sought to be enjoined can be fully and easily compensated, while, on the other hand, the defendant would suffer great damage, and especially if the public would suffer a large inconvenience if the contemplated act was restrained, the lesser right must yield to the larger benefit, the injunction should be refused, and the complainant remitted to his action for damages. This rule has been enforced in a multitude of cases, and under a variety of circumstances, and is one of such evident justice as needs no citation of authorities for its support. Second, when the defendant has an ultimate right to do the act sought to be restrained, but only upon some condition precedent, and compliance with the condition is within the power of the defendant, injunction will almost universally be granted until the condition is complied with. This principle lies at the foundation of the multitude of cases which have restrained the taking of property until after the payment of compensation. For in all those cases the legislature has placed at the command of the defendant means for ascertaining the value of the property. In those cases the courts have seldom stopped to inquire whether the value of the property sought to be taken was little or great, whether the injury to the complainant was large or small, but have contented themselves with holding that as the defendant had full means for ascertaining such compensation, it was his first duty to use such means, determine and pay the compensation, and until he did so the taking of the property would be enjoined. Third, where the defendant has an ultimate right to do the act sought to be enjoined upon certain conditions, and the means of complying with such conditions are not at his command, the courts will endeavor to adjust their orders so on the one hand as to give to the complainant the substantial benefit of such conditions, while not restraining the defendant from the exercise of his ultimate rights. Thus, in the case at bar, the defendant has of course the ultimate right to grade this street. As a condition of such a right is a payment of damages, but it has no means of ascertaining those damages, no tribunal has been created, no provision of law made, for their ascertainment. Hence, If possible, the court should provide for securing to the defendant this ultimate right, and at the same time give to the complainant the substantial benefit of the prior conditions. It was further held that in applying the rule first stated to a case like the one at bar, the court should have principal regard to three matters, viz., the amount of injury to the complainant, the solvency of the defendant, and the importance to the public of the proposed improvement. The courts are not in accord on the question, what right to compensation, if any, is given to owners of property abutting on a street by the constitutional provisions cited in this chapter, consequent on the authorized vacating of the street by the proper authorities. Granting that such right to compensation exists, in a given case, the owner's right to an injunction until damages are paid or secured would seem to depend on the usual principles regulating injunction against the exercise of the eminent domain power, where the abutter's easements in the street are taken or impaired. Section 1886. Section 472, Acquiescence. The equitable doctrine of acquiescence is freely applied to cases involving eminent domain rights. The underlying principle of the constitutional provisions allowing the taking of private property is that it is to be devoted to public use. Hence, when a landowner stands by until the public has acquired an interest in the use, there is a strong reason for applying the doctrine, in addition to the familiar grounds governing its application to other cases. The United States Supreme Court in a recent case has laid down the rule in no uncertain language. If one, aware of the situation, believes he has certain legal rights, and desires to insist upon them, he should do so promptly. If by his declarations or conduct he leads the other party to believe that he does not propose to rest upon such rights but is willing to waive them for a just compensation, and the other party proceeds to great expense in the expectation that payment of a fair compensation will be accepted and the right waived, especially if it is in respect to a matter which will largely affect the public convenience and welfare, court of equity may properly refuse to enforce those rights, and, in the absence of an agreement for compensation, compel him to submit the determination of the amount thereof to an impartial tribunal. Accordingly, when a landowner stands by and makes no attempt to enjoin a railroad company from building over his land until large expenditures have been made, or the road has been completed, injunctive relief will be denied, and the party will be left to his remedy at law for damages. The same principle applies to the laying of pipes or to a taking for any other public use. And although permission is granted to take upon the distinct understanding that compensation is to be made, an injunction will not issue, after the work has been done, for the purpose of enforcing payment. The doctrine also applies to cases involving the rights of railroads in streets. Section 1887. Section 473. Assessment of damages by the court, with injunction as alternative to their payment, where a corporation which has the right to acquire property by an exercise of the power of eminent domain has taken possession of property, and has erected or is engaged in the erection of structures thereon, but has not complied with some condition precedent necessary to render its acts in all respects lawful, such, for instance, as a failure on its part to pay some person the damage is necessarily incident to the maintenance of the structure, and such person appeals to a court of equity for an injunction to restrain the maintenance or to compel the removal of the structure, the court to which such appeal is made has the power to determine the amount of unpaid damages, and to withhold an injunction, and direct that the structure be permitted to remain and be operated, provided the assessed damages are paid. Courts of equity will, as it seems, the more readily pursue such a course when important public interests are at stake, and a contrary course would be productive of much public inconvenience and annoyance. This rule applies with special force when the complainant, by making no objection, acquiesces in the work. It finds frequent application in the New York elevated railroad cases, which are discussed elsewhere in this chapter.